I'm a fair housing coordinator with Project Sentinel, and I get the opportunity every day to investigate and advise or counsel people regarding allegations of housing discrimination. We also have Myra Magana.
Hello, my name is Mayra Magana, and I am the Senior Fair Housing Coordinator for Project Sentinel. I've been with the agency for 3 years, and along with that, I do advocacy work and also support the intake team. And I'm actually going to pass it to my coworker, Myrna, who's also on the intake team.
Hi, my name is Myrna Arriaga, Fair Housing Counselor. My job is to screen calls, counsel tenants, and do the initial intake. And also we are having a guest speaker, Noemi Guzman, a community housing advocate supervisor with Law Foundation of Silicon Valley. Noemi has been working with Law Foundation for 15 years. During her first 5 years, she worked on predatory lending, mortgage issues, and fair housing discrimination cases. Currently, Noemi works with a team of 4 other community housing advocates, educating the community about their rights as tenants and addressing some of the not so legal issues that they face in the Santa Clara county community.
Thank you, Myrna. So let's go ahead and move on here. I want to go ahead and briefly touch on our agenda today. We've done introductions. Know that throughout this presentation, we'll be covering the basics of fair housing, what it is, why it matters, who's responsible. We'll also touch on the barriers to housing, protections for families, sex discrimination, disability discrimination, what to do when you encounter discrimination, and we'll also have a wonderful presentation from Noemi Guzman covering the COVID-19 protections for tenants. We'll also provide you resources, and at the end, we'll definitely do Q&A. I encourage you to use the chat box if you have any questions. We will do our best to try to address all the questions at the end. I also want to point out that we will have an evaluation towards the end. So please fill those out. Those are very important for us. Let's see, we can go ahead and move on to the next slide. So who are we? We're Project Sentinel, and our mission is to develop and promote fairness and equality of housing opportunity for all, and to advocate for peaceful resolution of disputes for community welfare and harmony. And we're so fortunate to have offices in Fremont, Gilroy, Redwood City, Sacramento, and Santa Clara. And I am housed in the Modesto office. So I'm pleased to be here and to be able to share all these resources with you all. So what is fair housing? Let's see. So it's not a simple fairness. So let's go ahead and move on to the next slide. So fair housing means that it's not discrimination, right? Discrimination in in the fair housing world looks like in advertising, right? Sale or rental of housing, terms and conditions, termination of tenancy. So often when we work with clients, we get individuals letting us know that they're being treated unfairly, they're being treated unprofessionally, they hear negative comments, but that is not necessarily discrimination, housing discrimination. It is just inappropriate, obviously, demeanor from housing providers. What is discrimination, and you see it, and we'll touch on it, is in advertisements, in sales, in rental of housing, in terms and conditions, okay? And it must be based on a protected class. And we'll continue on. So there are 2 protected categories. There's the federal protected classes and there are state. So the federal protected classes are race and color, national origin, religion, sex, disability, and familial status. And just know that today we're focusing on a few of these. Throughout our workshops, we'll be delving a lot deeper and explaining to you all the definitions pretty much and what you can do to protect yourself. So this is the federal protected classes. So In the state, we have a lot more protections, so state protected classes. So we have marital status, we have immigration, age, primary language, gender identity, expression, age. The most newest one that was added was military and veteran status and arbitrary. So let me give you a little bit of statistics because that's always important, right, to know. So nationally, in 2019, HUD reported the following complaints as filed. So they received around 49% of complaints related to disability, 21% race, 11% sex, 9% familial status, and 9% national origin. Here locally, Project Sentinel has been able to gather data from July 2019 to June 2020, and we had a lot of complaints related to disability. 68% of our calls, are related to disability. 15% familial status, and we'll definitely touch on these protected categories, along with national origin, which is 10%, race 8%, and sex 6%. And I do want to point out that we've noted an increase in source of income discrimination complaints, and that's definitely due to our current climate. Next, please. So what is covered by fair housing law? We always get this question, right? And, you know, am I covered when we get callers? Actually, they won't ask us that question, but we'll figure it out for them. So, you know, what's not covered is in owner occupied housing where the owner only rents out one room. That's a narrow exception. What's definitely covered is most single family homes, multi-family apartments, shelters and transitional housing, nursing home, group homes, condominiums. So those are what's covered. Continue on. So when we have, you know, allegations of housing discrimination, oftentimes our clients aren't aware of who is responsible, right? And same thing with the housing provider. I'll tell you that basically everyone involved in a housing transaction is responsible under the law. And that is the property owners, individual or a corporation. It's property managers, the maintenance staff, believe it or not, administrative staff. I was surprised by that, maintenance staff, but they are responsible. Housing authority, voucher program administrators, lenders, real estate agents, brokers, insurers, homeowner, and condominium association, property management company, and so forth. So there's a long laundry list of individuals and corporations that are individuals that are responsible under the law. So I'm going to go ahead and turn it over to our my colleague here, and she'll talk about the barriers to housing.
Thank you, Anna. So I'm going to speak on national origin, immigration status, and source of income. Next slide, please. National origin, what is that? So essentially, it is discrimination based off of someone's ethnicity, birthplace, culture, language, ethnicity. And it can be the denial of the housing opportunities based off of these things, such as culture, customs, personal bias that people have, stereotypes. And some examples of those would be if a landlord refuses to make repairs based off of where someone's from. If they refuse to allow you to interpret or to use an interpreter or to bring someone to interpret for you. Be wary of statements or assume of cooking styles. So for example, if you have a certain culture that uses some type of spice or a lot of seafood, those things could be considered national origin if they make comments in regards to not renting to someone because of those things. Next slide, please. Immigration status. So in California, landlords, property owners, homeowners cannot deny someone or ask someone for their immigration status. A housing provider cannot require a social security number from an applicant. I know sometimes we have housing providers that have their practices in regards to asking for social security to run a credit check or a background check, and you don't necessarily need a social security number to run a credit check. But what they do have to accept is ITINs if the tenant is using one. An applicant shouldn't provide a fake social security number to fees the policy, because it could be considered fraud, and then it puts the tenancy in jeopardy. Housing providers do need to accept non-US identifications, such as Mexican consulates or passports from different countries. And it is illegal for a housing provider, a property manager, anyone in the housing world to threaten a tenant or a prospective tenant with immigration status, or turning their information over to immigration or the authorities based off of their tenancy. Somebody asked about an ITIN. It's basically a number that somebody uses to pay taxes to the IRS. So for someone that doesn't have a social security number. Next slide, please. So affordable housing and immigration status. So we get a lot of questions about if affordable housing programs can rent to immigrants. And some federally funded programs can determine or have immigration status to determine subsidy. They also can have mixed status families, which some can be undocumented, as long as someone in that household qualifies for the subsidy to rent. And it would be base prorated of the number of members in the household who are actually eligible. However, you do have tax credit properties that have 100% no immigration restrictions. And then if you need any more information, you can go ahead and check our immigration tool out on our website. Next slide, please. Source of income. So landlords, property owners, managers can't refuse or impose certain rental terms and conditions as long as the income is verifiable and of a legal source. So this also includes child support, foster care, any savings or pensions that you have. And it also includes benefits such as general assistance, CalWorks, things of that nature. And a housing provider cannot prefer one job over another. So for example, they can't say, we prefer Google employees versus retail employees. They have to, as long as the income is verifiable and legal, they have to accept it. And the way they can verify this is by pay stubs, tax returns, and then they can have a minimum income requirement. Next slide, please. Now, with the housing or with the Section 8, it's no longer legal for somebody to say no Section 8. I know sometimes we scroll through Craigslist, apartments.com, things of that nature to find housing, and you would usually see no Section 8. Unfortunately, that is, or fortunately, should I say, it's now illegal to say no Section 8. For the Section 8 and voucher holders, they can have a minimum income requirement, but it's based off of the tenant's portion of rent. So for example, if a housing provider has a minimum income requirement, let's say it's 2 times the rent, and the unit is $2,500, but the tenant's actual portion is only $500, that minimum income jumps from $1,000 only, because that's what the tenant's portion is, not $5,000 as a whole unit. Next slide, please. Now I'm going to pass it over to my coworker, Myrna, who's going to explain protections for family.
Okay, and now we talk about Protections for families and children. It is illegal to discriminate against household because of the presence of a minor under 18. This applies to pregnant tenants, adopted and foster children, and anyone who has guardianship of a child. Advertising for adults only or no pets or kids is illegal. Discouraging a family from renting a unit because of safety or because there are no other children in the community or because it's a quiet community of professionals are all examples of discrimination. Steering to the bottom floor or certain areas of the complex also are forms of discrimination. Restricted rules that discriminate. Occupancy limits that are below the 2+1 guideline keep families unhoused. Minimum occupancy limit should be 2 people per bedroom plus 1 person in the unit. 1 bedroom equals 3 people, 2 bedrooms equals 5, and 3 bedrooms equals 7. Statements or notices about children. No playing in common areas. Children must be supervised by an adult at all times, and are all discrimination. Recent issues due to COVID-19, such as distance learning, play areas, and noise complaints, which we've received a lot lately due to COVID. Next slide. So we have, just want to give you some examples of calls that we received in regards to the COVID-19 and children distance learning. Tenant called about getting a notice for noise complaints due to a neighbor who works night shift and usually sleeps during the day. The tenant did receive a notice from its property manager. There was another, for example, another call in regards to children doing PE that is required by school, that they do PE, and of course they're jumping, causing noise. And we have also received many calls about this kind of noise from callers. Now we have a scenario, and we want to know what you think. Martha applies to a 1-bedroom unit with her 2 children. Her prospective landlord asks her how she earns income, to show a copy of her social security card, who will care for her kids while she works, how soon she can move in, and if she has a boyfriend who will visit. Which application questions pass muster? Does the size of the unit matter? Would your answers change if this was an affordable housing unit? Now we have a poll, if you can kindly answer. Yeah, I think most of you guys have it correct. How soon she can move in is, and if it is correct. And as in regards to the affordable housing, yeah, you would need to provide a social security card. So yeah, most of you got it right. Thank you. Next slide, please. Discrimination based on sex. As of February 2021, HUD now interprets sex discrimination to include protections for sexual orientation and gender identity. Sexual harassment, illegal to condition terms of tenancy on response to sexual advances. Prohibition against harassment extends to management, maintenance, neighbors, etc. Domestic violence. Affordable housing properties and federal programs have VAWA obligations. Survivors should not have tenancies terminated due to abusers' criminal activity. California law offers law changes, early lease termination to survivors of abuse. And now to Anna.
Thank you, Myrna. Okay, so we are now in the disability discrimination reasonable accommodations information. I want to point out that disability is a federal protected category. And as I mentioned earlier, we get around 69% of our calls are disability complaints. So it's definitely high, and know that this is the #1 reason landlords have complaints filed against them, and the #1 way you can help tenants with disabilities fully access housing. Next slide, please. So what is disability? Disability is a physical or mental condition that limits one or more of a person's major life activities. For example, eating, walking, hearing, seeing, speaking, breathing, working, anything you need to do to perform your most basic functions of living and caring it's a major life activity, and it's part of disability, right? So are alcohol and substance abuse disabilities? I was a little unsure when I started working with in the fair housing world, but just know that fair housing law protects people who have a history of drug use, but not those who are currently addicted. So if someone's in recovery, they have fair housing protections because of a history of addiction, and it's considered a disability. Okay. So let's go on. So what does disability look like? So there's direct discrimination, folks, and there's a denial of reasonable accommodations and modifications. So direct discrimination could look like this. It could be a housing provider saying, I don't want a wheelchair to damage the floors. Okay. You're renting and someone says that, or I don't want someone sick to die in my home. They sound pretty shocking statements, but we hear them. They've been part of what we investigate. So that's a direct discrimination. Another discrimination is denial, refusing a reasonable accommodation or modification. Next slide, please. Okay, so what are the distinctions here? Most people get confused with reasonable accommodations and reasonable modifications. A reasonable accommodation is a change in rule, policies, or practices or services a disabled person needs in order to have equal opportunity to use and enjoy their home. So it's an exception to, and normally what we do, it's a lease, right? An exception to the lease, an exception to a rule. That's a reasonable accommodation that we can request. So the other option that we have here is reasonable modification. So that is a change in a physical structure a disabled person needs in order to have equal opportunity, again, to enjoy their home. And that simply is a physical change, a change in a structure. And we'll give you some examples next. So examples of a reasonable accommodation, and I do these all the time, and it's rewarding when I'm able to get, housing providers to grant these reasonable accommodations. For example, assistance animals, breaking a lease without a penalty because you have a disability. You're in a wheelchair and you need large print signs. You need a parking space. Let's say you're, in an apartment and you're way in the back, but you're in a wheelchair. You need to be able to get to your car quickly. We can request parking spaces to be for you to be closer to your apartment. So changes in rent due dates, that's also very important, and we get that all the time. Exceptions to score requirements, unit transfers. I do a lot of those reasonable accommodations where an individual might be on, the second or third floor. All of a sudden they've suffered some type of physical disability and they can no longer walk up the stairs. We'll ask for a transfer based on their disability. Rental history references. Another key one is extensions of time. So we'll ask for more time. Let's say, the housing provider has asked you to move out. They're going to go ahead and occupy their property again, and they want you out of their home. well, we can request more time, an extension of time based on your disability. Another one's second chances to comply with lease terms and so forth. So examples of reasonable modifications. So remember, that's a change in the structure, like a physical structure, right? So we can request, if you're a disabled person, request ramps, grab bars, lifts, widening of doorways, lower mailboxes or kitchen counters, and many more. So how can a tenant request a reasonable modification or accommodation or modification? This process always starts with the tenant or an advocate making the request. I will note that it could be at any time from applying through the whole eviction process. So don't think you have to do it immediately up front. And the request doesn't need to be in writing. However, we do recommend it so that we'll have proof that it's been done and for your records. And again, please note that when we request reasonable accommodations and modifications, there needs to be a connection between the disability and the request. So the specific accommodation or modification is necessary because of a disability. And again, I stress this, it does not need to be in writing. However, we do encourage it, and it could be done at any point during the rental process or eviction process. So let's go ahead and do a little homework here, put you to the test. So we have two scenarios, and we'll do a poll after. I'll read the question to you because I know we have some folks on calling in. So what do you think? So Susan has hundreds of dollars in late fees because her SSDI benefit comes on the 8th of each month, but her rent is due on the 3rd. Can Susan request a reasonable accommodation to avoid future late fees? So think about that one. Can she request an RA, reasonable accommodation to avoid future late fees? So the next scenario, Rodrigo needs a designated parking spot in a first come, first served lot. Okay, I think we're going to go ahead and do the first question. Awesome. Okay, people were awesome. I like that you're ahead. That's great. Okay, people are voting. Thank you so much for getting in there. Okay, I think the poll is in, the answers are in. So, okay, so for the first question, can Susan request a reasonable accommodation to change her rental due date? And the answer is a resounding yes, and you're absolutely correct. She can request that. It's her right as a person with disabilities. And does Rodrigo need to fill out properties form in order to request a reasonable accommodation? So do they need to fill out the properties form? So they're the documentation that they have. The answer is yes and no, okay? So technically he doesn't need to fill it out because again, we don't know what the disability looks like, right? They're not obligated to fill it out. However, we always encourage our clients to keep copies and definitely follow through with completing certain forms. However, that's when we step in and we look at the forms. You know, is it burdensome for them to do it? Again, it does not need to be done. Okay, so thank you for that. I appreciate you all participating in the poll. So I want to go ahead and move into tips for tenants. I slightly mentioned some tips earlier, right? And I think the number one thing that we see here at Project Sentinel, you know, when we're helping individuals is that they fail to keep documentation. So keeping copies of important records is so important. For example, having a copy of your lease. I know sometimes individuals don't even, get a lease. There's no contract agreement. There's nothing, right? But just having something that says your connection to that individual that is providing the property is very important. Community and household rules. Earlier, Myrna mentioned, protections for families, right? Familial status protections, children, right? So what are the rules? Are tenants receiving notices regarding the community household rules that discriminate against minors, and if you are, we want to see that. We want to be able to have proof. So notices, even if they're sent to all tenants. Rent receipts, that's a huge one. And I've been guilty of that. We usually throw away my receipts, but definitely keeping all of these documents is very important. And definitely, when possible, follow up with a verbal request with a written confirmation. So definitely that's key to have documentation. I want to stress that, of all these things that I've mentioned. So how can we help you, and how do we help you? So I'm very thankful that we're able to offer free counseling services, education, and investigations to people that allege housing discrimination. We serve anyone, regardless of language, income level, immigration status. While we don't offer legal advice to landlords, we do reach out to our other partners, and they're able to step in. And know that we're here for you. We have our phone number listed on this slide. Hopefully you're all able to see it, but if you're, calling in, I'll read it out loud: 888-324-7468, or you may reach us at fairhousing@housing.org for more information, or if you have questions. Okay, so let's go ahead and I will turn it over to our guest speaker, Noemi Guzman from the Law Foundation, and she'll provide us more information on a very important topic that I mentioned earlier, and that's the COVID-19 protections.
Good afternoon, everybody. Thank you for being here. I know this year has been a tough year. My name is Noemi Guzman. I'm the Community Housing Advocate Supervisor here at Law Foundation. And so I just wanted to share some information with you all regarding SB 91, COVID-19 eviction protections, and some information on the CDC order on evictions. So I'm going to go ahead and start sharing now. Just a second. Okay. Can you all see my screen? Awesome. Thank you. So we're going to talk today about COVID-19 eviction protections and the CDC order that is out right now. I will briefly go through what Law Foundation does and what our roadmap basically is. So basically today we'll talk about what Law Foundation does, how long we've been in the community. I'm going to give you a bit of background on COVID-19 tenant relief, which is SB 91, some current protections under SB 91. I'm also going to give you information on the CDC order and evictions, and a very short piece on the eviction process, just so that way you are more familiar with how evictions work. So the Law Foundation of Silicon Valley, our mission, of course, is to advance the rights of underrepresented individuals and families in our diverse community through legal services. We do this through strategic advocacy and educational outreach. Our vision is to achieve social justice in Silicon Valley and beyond through vigorous legal advocacy. Our approach here at the Law Foundation uses innovative legal advocacy as a tool for social change. We've established more than 40 years ago. Today, our team of 90 attorneys, social workers, and staff, together with pro bono volunteers, find stable homes for abused and neglected children, help people living with chronic illnesses, access the benefits they need to remain healthy and self-sufficient, provide low-income people access to safe and affordable housing, and address a number of other critical issues, including domestic violence, discrimination, human trafficking, and mental health, and more. So here's a bit of background on SB 91. Many of you may remember AB 3088, which was basically created back in March of 2020 when this pandemic first started, to help tenants who were dealing with the pandemic and had a loss of income. So AB 3088 created the COVID-19 Tenant Relief Act, which provides protections against evictions. AB 3088 took effect August 31st, 2020, and was set to expire January 31, 2021. SB 91 passed at the end of January, which basically extended the protections until June 30th, 2021, which was awesome because lots of folks were calling in concerned about what they were going to do starting February 1st. They didn't know what type of protection was going to be out there. So SB 91 came just in the nick of time. So SB 91, what is the big picture here? So SB 91 prohibits evictions until June 30th, 2021. And those evictions are based on non-payment of rent when tenant did not pay because of COVID-19. It is super important that it's not just a tenant saying, I've been affected by COVID-19, but that they have also returned a declaration of financial distress to their landlords. Now, this declaration must be provided to your landlord. So tenants are protected if they have lost income or have had more expenses from COVID-19. When protected, tenant could never be evicted for the unpaid rent for applicable time period. So a landlord can collect rent in the small claims court starting August 1st, 2021. So basically, a landlord at this point cannot take you to small claims court and try to collect for any back rent. That ability is not to take effect until August 1st, 2021. So rent is rent plus other financial charges due under the lease, such as utilities. So SB 91 is not just protecting for rent, it is also including any utilities that you are being charged along with your rent. So it's super important that we understand that it's not just your rent payment, but it's also some utilities that could be included in your rent. So SB 91 non-payment rent. So two key time periods for non-payment protection. So it's super important that we remember that since this pandemic has started back in March 1st, 2020, it had a few different pieces of protections that were included under SB 91. So we're going to talk about two time periods. We're going to start with March 1st through August 31st, 2020. So during March 1st through August 31st, tenants were not obligated to make any sort of rent payments. During this time, as long as you notified your landlord that you were being impacted by COVID, that was sufficient enough notice for them not to be evicted. So it is super important that you understand that during this time, Santa Clara County did have protections for tenants, which meant that if you were not able to pay any of your rent starting March 1st through August 31st, you did have to start making a payment to your landlord starting February 28th, 2021. Which basically means any rent that you owed between March 1st through August 31st, you had to pay at least half of your debt by February 28th, 2021. The other half of that debt from March 1st to August 31st needed to be paid no later by August 31st, 2021, which basically means that you were given a full year to be able to pay any unpaid rent from March 1st, 2020 to August 31, 2020. So it's super important. A lot of folks were not sure when to make any of these payments. So if you have some doubt, feel free to reach out to us. But this is basically the breakdown for the first half, March 1st, 2020 through August 31st, 2020. So tenants could face a small claims lawsuit for any of the unpaid debt, but still cannot be evicted for it. So basically, let's say February 28, 2021 came around and you were not able to make that 50% payment for that first time period. It didn't mean that you were then going to be evicted. It simply meant that now a landlord could go into small claims court and file a claim against you. Now, it may be that a lot of the landlords may be waiting to file any small claims court action until after August 31st, 2021, to see if there's a possibility for tenants to be able to pay the full amount during that time period, which is basically your deadline for the first half of the rent that needs to be paid from March 1st, 2020 through August 31, 2020. Now, here's the second half, and this is the most important part. So the second half covers September 1st, 2020 through June 30th, 2021. June 30th, 2021, which is when SB 91 is set to expire. So for this time period, folks needed to pay at least 25% of their rent to avoid eviction. So rent for this period cannot be the basis of an eviction if tenant submits a declaration of financial distress for each month and pays a total of 25% of the rent and other financial charges due in the lease for the entire period. Lump sum at the end is okay. So basically what this means is if folks cannot pay the 25% of rent each month, they are being given until June 30th, 2021 to pay 25% of the months owed from September 1st through June 30th, 2021. Now, the one thing that is very important, and I have to stress on this one, is that tenants must provide their landlord a declaration saying that they are still being impacted. Now, a lot of tenants are only doing this every once in a while, but it's important that that declaration be submitted each time that a tenant gets a notice, and we'll go through the notice as well. So a landlord can pursue a small claims lawsuit for the rest of the unpaid debt starting August 1st, 2021, but cannot evict the tenant for it. So that's the one very important piece that we must remember here. As long as tenants are paying that 25% of rent from September 1 to June 30th, 2021, tenants cannot be evicted for non-payment of rent when they have been impacted by COVID. So what are the claiming protections? So any notice that demands rent for March 1st through June 30th, 2021 must give a 15-day notice and attach a blank declaration of financial distress. Any notice served on or after February 1st, 2021, there must include specific language informing tenant of right to apply for rental assistance. So there are very specific pieces to these notices that need to be in the document. And so I will be able to show you what that will look like, the declaration, okay? Claiming the protection. So again, tenants must attest that they have been impacted by COVID by returning the declaration of financial distress signed under penalty of perjury to their landlord. So the declaration of financial distress must be returned within 15 days of receiving any notice of non-payment of rent. Tenants making more than 130% of the area median income may need to supply additional documentation. So this piece, a lot of folks are calling in and saying, do I need to provide my landlord with like copies of my unemployment checks, time cards, a letter from my employer saying that I'm not working at this point? No. The only time that you do need to provide any of that type of information is if you have been a tenant that has been earning 130% of the area median income. So basically at a higher percentage, that's when a landlord is able to request additional documentation to be able to prove that you have actually been impacted by COVID. So let's talk a little bit about what those impacts look like. So under COVID-19, the impact definition is loss of income caused by COVID-19 pandemic, increased out-of-pocket expenses from doing essential work during COVID-19, increased expenses related to health impact of COVID-19, increased responsibilities or costs for caring for children, or an elderly, disabled, or sick family member directly related to COVID-19 pandemic that limit ability to earn income. some of the other circumstances related to COVID-19 pandemic that have reduced your income or increased your expenses can also be part of the impact. So tenants only need to sign the declaration of financial distress stating they have been impacted in one or more of these ways. No need for additional proof of documentation unless you are a high income tenant. And this is what the declaration of financial distress looks like. So this form is a very simple form. It's a very short form. It basically just has 6 points talking about which COVID impact you may have had. It's super important that you sign this and date it if you have been impacted by any of the 6 that are listed on the notice. And it's important that you make sure that you return this declaration within the 15-day time period. So basically, you would be getting a 15-day notice for non-payment of rent. The declaration does need to be attached to that 15-day notice. It is important that once you get that, if you are being impacted by COVID, that you sign the declaration and return it as soon as possible. Now, it's also super important that you know that weekends are not included in the 15-day time period, nor are holidays. But it is important that you do at least turn it in the sooner rather than later and keep a copy of it. Take a picture of it just to be able to have as proof that you have turned in the declaration to your landlord. So here's a couple of tips on turning in the declaration. Must do this to protect yourself. 15 days to submit, excluding Saturdays, Sundays, and other judicial holidays. How to turn in the declaration of financial distress. Must turn in specific ways. So it's super important that when you do get your 15-day notice, it will state on there how you can turn in your declaration. So it's important that you look at the notice and you see, is it marked that you need to turn this in person? Do you need to do it? Can you do it electronically? Do you need to do it by mail? If it is in person, only if the notice provides address for in-person delivery, okay? By electronic transmission, you can turn it in if the notice provides an email address. And by mail, an address provided in notice. Now, it should be super important that you, if you get the notice, that there is an actual address that's being provided for you to be able to mail the copy. Now, it's also important that you get proof of mailing. So it's either sending it by certified mail or with a certificate of mailing, just so that way you have proof that your manager, landlord, owner of property has actually received the document. Do it in any way you can prove you turned it in. Date it and keep it a copy or picture of it. Super important. So here's a couple of questions that come up. What if the tenant misses the 15-day deadline? So even if a landlord tries to refuse the declaration, turn it in anyway. There's still an opportunity to submit the declaration of financial distress once an unlawful detainer, or in this case, an eviction case, is filed. So let's say that you didn't turn it in within that 15-day time limit. It's super important that you attempt to do it anyways. Send it certified mail if that's a possibility. Email it, send it through electronic form. As long as you are able to do it, it will still help you in some way if you are ever faced with an eviction based on a non-payment of rent because of COVID-19. So it's super important that if you did not turn it in within that 15-day time limit, that you still do so, and then right away reach out to a legal services agency to try to get help on an eviction if one is filed against you due to missing that declaration and the 15-day notice. So the court will hold a hearing to determine if the tenant has a good reason to miss that 15-day deadline. Some folks may have not received it in time. Some folks have lots of other things going on. Maybe they were in the hospital with COVID. Maybe a child or a relative was ill or needed care. So it's super important that you, even if you don't turn it in within that 15-day time limit, that you still try to turn it in after. So here's a couple of things that we need to make sure we understand. So late fees, late fee protections under SB 91. So a landlord cannot charge or attempt to collect late fees for COVID-19 rental debt when tenant returns a declaration of financial distress. So lots of folks are calling in saying, hey, my landlord took my declaration, but is still saying that I owe $100 of late fees for each month that I have not been able to pay my rent because of COVID. So it's super important to know that landlords cannot charge for those late fees. So COVID-19 rental debt is rent or any financial obligation that came due March 1st through June 30th, 2021. It is not late fees. So landlord also cannot increase fees charged or charge for services the landlord previously paid for when tenant has provided declaration of financial distress. For example, if the tenant did not pay for trash and water, the landlord cannot start to charge for trash and water once tenant has returned the declaration. So that doesn't mean that just because you're not paying rent, and if your rent included your water and your garbage, that doesn't mean that now that you're not able to pay the rent, that then you still have to pay it separately. If that was part of your agreement when you first started living in the unit, it should continue even if you are not able to pay your rent. Rental debt protections. Okay, so landlords can't use an alleged COVID-19 rental debt as a negative factor to evaluate rental application to refuse to rent because of COVID-19. A lot of folks are calling in and saying, hey, I'm going to move. Will that affect me because I was not able to pay my previous landlord because of COVID-19? No. So technically, they cannot be using that as a factor to why they will not rent to you. So COVID-19 rental debt cannot be sold or assigned until after July 1. What does that mean? So once rental debt is created and you are taken to small claims court, the landlord cannot sell that debt to try to get it collected through a third-party agency. That cannot happen until after July 1st, which is basically the day after the SB 91 protections have ended. So COVID-19 rental debt can never be sold or assigned if the tenant with the debt is low income. So that's another very important factor. Low income is defined as 80% of the area median income or someone who would have qualified for rental assistance. So under SB 91, there are just cause protections. What does that mean? It means all tenants are entitled to just cause protections until July 1, 2021. For tenants in all types of housing, the landlord must have a reason to terminate the tenancy. Just cause reasons to terminate a tenancy include but are not limited to non-payment of rent, criminal activity, nuisance, owner move-in. For some at-fault reasons, the landlord must give the tenant an opportunity to fix the problem. We are seeing a lot more cases of these where tenants are being given notices for nuisance, where it could be that the underlying factor is that the tenant actually just owes rent. And so landlords are creating situations where they're putting tenants in a situation, making it seem as if the tenant is creating a nuisance. So it's super important that if tenants are facing these types of situations, that they do reach out to a legal services agency. So SB 91 established state rental assistance programs. So it's super important that you apply for it. Rental assistance applications must be available by March 15, which they are. Keep really good records of payments and document how they should be designated. Consult with an attorney if you can't apply or get denied and have any problems. We have slowly started to see and hear about people who are applying for the rental assistance program. We would love to talk to folks about what their experience has been trying to apply. We're more than happy to give information on where you can apply. So if you have questions, you can reach out to us as well. And let me just give you information on who is eligible. So households must meet the following 3 eligibility requirements as determined by the rental assistance provider. At least one member of the household has qualified for unemployment benefits or lost income or increased expenses related to COVID-19. The applicant must attest this in writing. So you need to have it in writing that someone in the household has needed to collect unemployment or has qualified for unemployment or has had an increase in expenses because of COVID. Number 2, a member of the household can demonstrate a risk of experiencing homelessness or housing instability, which may include a past due utility or rent notice or eviction notice. unsafe or unhealthy living conditions, or any other evidence of such risk as determined by the administering rental assistance program. And number 3, the household income is 80% of the area median income and below. How much is it? Assistance could be used for any of the following depending on what the landlord agrees. So you could use the financial assistance for rental arrears. So any rent debt that is owed from April 1st, 2020 to March 31st, 2021. So what that means is if a landlord is on board and agrees to 80% of that debt from April 1 to March 31, 2021, the landlord must also agree to waive the remaining 20%. Now, the other way that folks can get help is if they want to be able to get help for future payments. Now, that part of it is only limited to 25%. Now, the other piece it does cover is utilities, including arrears and prospective payments for utilities. Assessing rental assistance. After tenant or landlord applies, the rental assistance agency will contact the landlord to offer rental assistance. If the landlord accepts the assistance, they will receive 80% of the rent debt that you currently owe. The landlord cannot evict you for non-payment of rent for the rest of the lease if they accept this payment. So if the landlord refuses to accept rental assistance directly, the tenant can request assistance for back rent or future rent payments. Payments made directly to tenants will be 25% of their back rent and or future rent payments. So this is where it becomes a little tricky. We want to encourage landlords to apply for their tenants simply because it's a better benefit for both landlord and tenant. If a landlord applies and a tenant applies and they are in agreement together, it does reduce a tenant's debt by 80% because the financial assistance program will be paying off 80% of that debt as long as the landlord is on board with forgiving the other 20%. Now, when a landlord refuses to accept the rental assistance, that puts a tenant in a situation where they're only able to receive 25% of rent, either for future payments or for arrears. Now, the other order that is the federal order and that is still in effect is the CDC order on evictions. So CDC order prohibits some evictions from going forward until June 30th, 2021. It was recently extended from March 31st to June 30th. So SB 91 offers more protection. So in most cases, tenants will benefit from the SB 91 protections and will not use the CDC order. But it may also help tenants in particular circumstances. So for example, a tenant can provide a declaration at any time under the CDC order. No 15-day time limit. There's a CDC declaration form available on the CDC website. There's no need for COVID-specific hardship under the CDC order. Instead, income loss, increased expenses, income below $99,000 or $198,000 for joint tax filers and other qualifiers. So this CDC order may stop a sheriff's lockout after losing in eviction court. It includes enhanced penalties for landlords that do not comply with the order. So if you are thinking that maybe a CDC order could fit your situation, it's important that you seek legal assistance to see if you qualify. And now I want to touch on the eviction process. The eviction process is as follows. Landlord must go through an unlawful detainer, basically an eviction court process to evict any tenant. A landlord must provide formal written notice. So prior to a landlord being able to go to court and file any documents in court to sue a tenant, he or she first needs to supply a notice to the tenant, either 3 days, 30 days, 60 days, 90 days, etc. A tenant has a right to respond. So it's super important that anytime you receive any eviction documentation, that you reach out to a legal services agency like ourselves and be able to get the help to respond to that documentation. You do only have 5 days to respond to any sort of eviction document from the court. So there's no lockout until after the court has entered the judgment and the sheriff has posted a notice to vacate. A lot of folks think that once they get this 3-day notice or 30-day notice and it expires, that immediately a sheriff can come and lock the door. That is not the way it works. A landlord has to go through the eviction process through the court, has to file the documents in court. A tenant has to be served. Now, once tenant is served, it is now up to the tenant to respond. If tenant does not respond, it does give the landlord the ability to move forward and be able to file the lockout notice with the sheriff's department. So it is super important that you do seek legal assistance sooner rather than later to be able to respond to the eviction and avoid a sheriff notice. And again, this talks a little bit more, starts with the notice, landlord files unlawful detainer. So the landlord is considered the plaintiff, serves the tenant with a summons and complaint. Tenant is the defendant. Tenant responds to summons and complaint within 5 days. This is usually an answer, but again, you can reach out to us to talk to us about what that means. There is a trial, which means it is in person. Trial is set between 10 to 20 days after the answer is filed. And then there is a judgment. Now, judgment means either you win, lose, or you come to some sort of settlement. Now, if for whatever reason you end up losing, then a sheriff can issue the lockout notice. It does give you still some more time, and there are still some more things you can do at that point to try to prevent yourself from being evicted right on the date of the notice. You can buy yourself some more time. So it's super important that you reach out to a legal services agency to get some more information like ourselves on how to do that. What do tenants need to know? So I think the one and most important thing that all tenants need to know is don't move. There are protections for tenants who have been impacted by COVID-19. We're seeing lots and lots of folks thinking that if they vacate the unit they're currently in, that they're able to find something that's cheaper, that might actually be beneficial. It's super important that before you make any sort of decision of that sort, that you do reach out to a legal services agency simply to understand what your legal rights are. And so that way you can make a better decision. If you did not pay rent between March and August 2020, your landlord cannot kick you out if you sign and return a document stating that your income has been affected by COVID-19 within 15 days of receiving any eviction notice. This document must be included with the notice. For rent due between September 2020 and June 2021, you cannot be evicted if you signed a document that your landlord gives you to say that your income has been affected by COVID-19 and you pay at least 25% of your rent from September 2020 to June 2021 by June 30th, 2021. All eviction cases for non-payment of rent between March 4th, 2020 and June 30th, 2021 are masked from the public regardless of outcome. And where to go for help. So, you can give us a call. We do housing discrimination. We do tenant issues and evictions. And so our phone number, if you want to reach out to us, is 408-280-2424. You can reach us through our website. We do have an online intake form that you're able to fill out with any questions or concerns. And that's at www.lawfoundation.org/housing. And again, you can reach out to Project Sentinel. And so I think that's basically it. If you all have any questions that you need answered.
Thank you, Noemi. That was great information. Thank you so much. That clarified a lot of my questions. So there's her website, her contact information. We'll also include it later on and as we send out information. So let's go ahead and go back. We have a couple more things. I know.
Sorry, let me just stop sharing here.
Okay, thanks.
There you go.
Okay, so let's go ahead and get into the Q&A. Earlier we had a question regarding scenario 1, Martha's scenario. I don't know if we can get it up. We had an individual needed a little more clarification. I don't know if we can get the question up again. Okay, let me see. Maybe it's here and I'm missing it. Thank you so much. Aya's in the background. She's doing amazing work. Thank you, Aya. Okay, so here's the question. So Martha applies to a 1-bedroom unit with her 2 children, okay? Her prospective landlord asks her the following questions. Asks her how she earns her income, to show a copy of her social security card, who will care for the kids while she works, how soon she can move in, if she has a boyfriend who will visit. So all those questions. So which of those questions will pass muster? So which ones are appropriate? So let's go one by one, okay? So can the landlord ask about how she earns income? The answer is yes. It's an appropriate question. However, the landlord needs to be able to accept all forms of income, okay? To show a copy of her social security card, yes, they can do that. However, they can't deny her if she has a different form, for example, an I-10, okay? Who will care for the kids while she works? This one is an inappropriate question because it appears that they're making assumptions about whether or not she's a single mother, and that's not okay. How soon she will move in, that's completely fine. Actually, that's the safest one, right? When she will move in. If she has a boyfriend who will visit. So if you have a landlord that's asking you these questions, well, when's your boyfriend going to move in? That's not appropriate. That's getting at, you know, her marital status. And that's not okay. So hopefully that answered the question that we had asked earlier. So any other questions? Okay, I think we have a question here from Jaden. Hi all. So a tenant is refusing to move out and also not wanting to pay rent, although he has income. How can we assist the landlord in this matter? Okay, I hear crickets. So let me take a stab at it here. So a tenant is refusing to move out, and also, actually, that might be a question. Yes, that might be a question for Noemi. Thank you.
Hey, so which one are we looking at? Sorry, I was looking at the Q&A and I got distracted by some of the other questions on there.
Don't worry, I'm reading the one from Jaden Tran.
Jaden Tran. Is it in the chat or in the Q&A? Because I see 3 up on the questions and answers, but I don't see Jaden.
Naomi, I think it's in the chat.
Okay.
Thank you, Myra.
I think actually it's the first one, the lowest one, the one that.
Okay, so a tenant is refusing to move out and also not wanting to pay rent, although he has income. How can we assist the landlord in this matter? Well, here's the thing, and I have to say this. So the Law Foundation is an organization that helps tenants. So anytime a tenant has a specific question about what to do with their landlord, we ask that they reach out to us. When it's a landlord asking a question, we usually refer them out. So this seems more of a landlord question. So I don't necessarily think that I could give you that type of information. Now, if you are the tenant, I say reach out to us. I can give you our phone number again, and you can call us and we can give you information on how to deal with that situation. I'm also happy to answer some of the other questions that were posted in the Q&A.
Please do. Thank you, Noemi.
Yeah, no problem. So I think you, Will Taylor, you had a question about, can you say more about the masking? So basically, masking, what that means is anytime an eviction is filed in court prior to COVID, it is basically a public record. It only stays private for 90 days during the process of the eviction, and then after it becomes a public record, which means anyone can go to the courthouse, look up information based on someone's name, and be able to get documentation information about why someone may have been evicted. During this pandemic, they have basically under SB 91 masked or basically covered, it remains confidential for the time period of the pandemic. So what that means is the public cannot come in, look through records, and try to get information about why someone was evicted, because it will not be available for them to look through. Okay, I'm hoping that answered that question. If you have another one, I'm happy to follow up. And then I think there's another one. I have a question for the Law Foundation. What if a client was impacted by COVID, submitted statement of declaration informing landlord that she can't pay past due rent? The tenant received an unlawful detainer, and the landlord shares that he is taking the property off the market and will be using tenant's deposit to pay her past rent. What can client do then? So in this situation, she may not have rights. I'm sorry. So Delma, I'm not sure if this is a tenant or if this is a person who actually owns the home. So here's what I have to say. Anytime a tenant is facing an eviction and it's based for non-payment of rent and they have been COVID impacted, I always say, give us a call. We can advise the tenant on what to do from there. A lot of it is going to depend on the details of the situation. If the tenant is wanting to stay in the property or needs to figure out for more time to be able to vacate and move somewhere else, there are situations where we can help, whether it's asking for more time. It also depends on where this person is at in the unlawful detainer process. Is it that the person already filed their answer? If they have not, do they need to? And do we need to help with that? Is it a person that is already at the end of this? Maybe they've already gotten a decision through trial, and maybe they're now being possibly served with a sheriff notice. And so that's where we need to just be able to talk directly to the tenant and be able to advise depending on where they're at in the process. So I know there's been some talk about whether it matters if it's a single family home or a apartment. All housing is covered under SB 91. It doesn't matter if it's single family home or not. I know a lot of landlords are threatening to put the property on the market as a way to get tenants to vacate the units. It is super important that if those tenants are facing a situation like that they do reach out to us, because there are some pieces of information that need to be given to a tenant if a landlord is going to put the property on the market. I hope that answered that piece of it. So the other thing, I think it looks like Nadia Yivia, how is the 80% AMI income determined for eviction protections and rent payment assistance? So actually, if you go into the internet and you just Google Santa Clara County 80% AMI income, it does give you a breakdown of where people would fall. If you still have a question about whether or not you fall under that percentage, you feel more than happy to give us a call and we'll answer questions about where you would fall in that type of piece.
Thank you so much, honey. This has been great. Thank you so much for all your wealth of information. I think we've answered all the questions. Again, please feel free to email us if you have further questions, call us. We do have 2 more upcoming events, Symposium events on May 5th, Fair Housing Protections for Families, which we briefly touched on, and May 14th, Public Policy, Gender and Sex Discrimination. I will be sharing the link to those webinars right now. Also, focus topics on webinars. We do have some upcoming ones, the 27th, May 11th, May 25th. And again, the links are there. What else do I need to share with you folks so you will have as much information as possible? Let me go ahead and share this. Oh, wow. So I'm sure, did you not hear any of that? I'm so sorry. So again, thank you so much for coming. We do have some events, symposium events coming up, May 7th, May 14th. These are great topics. I encourage you all to sign up and to show up and ask questions. We have also some focused topic webinars coming up on the 27th, the 11th, and the 25th. I've just sent out a link to the webinar. And again, if you have any questions regarding what we've presented today, please feel free to email us, call us. We're here for you and want to be able to provide as much information and guidance as possible. Next. Okay, well, thank you so much. Thank you everyone for your time. I hope you all have a wonderful afternoon, and we will be hopefully in touch somehow. Thank you so much. And of course, I forgot to mention our evaluation. I know some people are participating in that. Please do so. That's very important.